Hey, please, we'll begin now. We are live streaming on YouTube too, so we can kickstart. Jesse, please, you can take over. Thank you.
All right, I'm so grateful. And once again, I apologize for the network issues that I've been facing. I had to quickly dash into the office to have this meeting with you. At least within the office, I'm assured of a stable internet connection. Yes, so I hope we can continue from where we stopped, or would I have to start all over?
Oh, we can
Please
continue.
start. Some of us were not in that class, so if you could start for us, please. For a brief recap, please.
And thanks for the effort.
Hello, Jesse, please, we can hardly hear you.
Is Jesse still having problems with his network?
Yes, please, let's hold on for a minute. I think he went off. Oh.
Hello.
Hi, please hold on.
The person you're calling.
Please hold on. Hold on for a minute.
Hi,
Yes.
I'm here.
Thank you, Jesse.
Hello, I'm here.
Yes, we can hear you. So please begin.
Yes, I think today the devil is a liar. I don't know.
Yeah,
The witches
of
and wizards
course.
don't want us to have this class.
Amma, please put it on our pages for those who have
Yes.
not.
Yes, please. I have. Thank you.
Hello, good morning, seniors.
Good morning.
Hello, please let's hold on a little. He's trying to rejoin again. I believe he was having the same issue.
Hi, am I being heard?
Yes, please. We can hear you now. Thank you.
Okay. Sorry again. I don't know why the witches and wizards are up in arms against us. Anyway, I think we'll just have to continue from where we stopped. We just had introductions and we were reading a question before the internet connection started messing everything up. I would like us to look at this particular question. and someone was ready to take it. Let me read it again so that if the person is online, the person can also proceed from where she started. Now, the question reads that you have been awarded a Bachelor of Laws LLB degree from a university in Ghana. In the gap period before you enter law school, and you have taken up an internship at Ghana's Law Reform Commission. The government of Ghana, with assistance from the World Bank's Legal Sector Reform Program, has initiated reforms in Ghana's legal sector, with the Commission as the lead government agency. A delegation from the World Bank is to arrive in Ghana for initial discussions on the reforms and had requested that the Executive Secretary of the Commission provides them with a concise brief on the sources of law in Ghana. The Executive Secretary has asked you for a draft of the brief. Write a brief. And we had someone who was ready to assist us with in answering this particular question.
Please,
I just want to take your views on this question. Okay. Yes. Please, what's your name?
Priscilla.
Priscilla, please carry on.
All right. So, as I stated earlier before the line dropped, I said that this question is strictly on the discussion or current discussion on the sources of law in Ghana. So, we can find in our book, specifically E.K. Kwanzaa's legal system book, which says that the term source of law is said to have several meanings. And one of such meanings is that the source which gives the law its formal validity. An example of such is the Constitution itself. So, with this being said, you can go to chapter 4 of the Constitution 1992, which is Article 11, and it stipulates that the source of law in Ghana shall comprise of the Constitution, enactments made by Parliament, rules or orders made by persons or authorities under powers conferred by the Constitution, the existing laws, and then the common law. With this being said or written, you would have to take the listed sources and then explain them further. Commencing with the Constitution, which is recognized by Article 11.1 as one of the sources of the source of law in Ghana.
You're breaking off. Or is it from my end?
I think so, because
I think it's from your end.
It's from
clear.
your end, Council.
Should I carry on? Please,
Yes,
can I go
please.
on?
Yes, Priscilla.
Okay. So you discuss or explain what the Constitution is. And the Constitution under Article 1, Clause 2 established that the Constitution itself is the supreme law of the land, and any other law found to be inconsistent with the Constitution shall be declared null and void. This was affirmed by the court in the 31st December case, the NPP versus AG, and then the Mensima versus Attorney General. So that would be my explanation or discussion on the Constitution. The second one to talk of is enactment made by or under the authority of Parliament. This is widely known as legislation. And then in Ghana, under Article 93.2, the law provides that the legislative power of Ghana is vested in Parliament, which shall be exercised in accordance with the Constitution. So this is to the effect that Ghana doesn't recognize supremacy of Parliament, but rather the Constitution. Hence, all their legislative powers or exercise shall be in accordance with the Constitution. So in the case of Mensima versus Attorney General, the court acknowledged or established that by the provisions of Article 1.2, or the provision of Article 1.2 is a bulwark, which does not only fortify the supremacy of the Constitution, but also makes it impossible for any other law found to be inconsistent with the Constitution to be given effect to. So this can also be the end of the legislation. Then we move on to the rules, regulations, and orders made by persons or authorities under a power conferred by the Constitution, as provided by Article 11 C. Sure.
Hello,
Okay,
Priscilla.
so yes.
You can kindly stop there. Is there any other person who would want to also contribute to it?
Yes, Councillor, I also want to add some little flesh to Senior Priscilla's presentation so far.
But please hold on, Priscilla.
name-
Priscilla. That's a very good submission, a very good attempt. Well done. Yes, Senior, please continue. Please, what's your name?
My name is Ramson Atindogo.
Okay.
I'm a graduate of UCC and a member of the Legist preparatory classes.
Okay. Please let me hear you, sir.
Yes, so a question of this nature, obviously talking about the sources of law in Ghana, I am of the view that it will take this format. You would first of all have to attempt to define what the law is. And the law is defined under four main perspectives: the naturalist perspective, the positivist perspective, the realist perspective, and the socialist perspective of the definition of the law, with the various proponents of those theories. And when you do justice to that, you have to zoom into some brief delivery on the functions of law as prohibitive, as permissive, and then directive. And you add some little flesh to that. Then you move on to the sources of law itself. And then the sources of law, Article 11 is okay, but Article 11 falls under one of the categories of sources of law, which is the formal sources of law. And so you have to make the examiner understand that the sources of law is grouped into four main categories. Okay, one is the material sources of law that talks about the textbooks, that talks about the law reports, the statutes that you can make reference to, where the law can be found. Those constitute the material sources of law. Then you can also talk about the historical sources of law. The historical sources of law primarily talks about the reasons or the relevance or the ideation behind the promulgation of a certain law. For instance, under the lawmaking authority of Parliament under Article 106, bills that must be sent to Parliament must be accompanied with an explanatory memorandum. The explanatory memorandum gives the rationale. What lacuna is this law coming to fill? What is the problem at stake? Somebody is
Can you mute, please? Let's check our devices and mute.
Yes.
Yes, please. If you are not on the floor, sorry to interrupt you, sir. If you are not speaking on the platform, kindly mute, and so that we will be able to follow the discussion. Thank you.
Grateful. So may I proceed, please?
Yes, please.
So
You can.
that talks about the historical sources of law, the explanatory memorandum. This was emphasized by the courts in the case of Ezwami Manan versus the Attorney General, where it was stated clearly and explicitly that every bill that comes to Parliament must be accompanied with an explanatory memorandum. So the explanatory memorandum gives the history and the reasons that ground the promulgation of that law. So after saying that about the historical sources of law, then I come to the legal sources of law. And under the legal sources of law, you are talking about the processes or the ways and means that gives the law its validity, its acceptability, and its legal status. And so under the legal sources of law, you are talking about the processes by which the law comes into force. So under Article 106, clearly stipulates the procedure that a bill must pass through up to attaining presidential assent, being gazetted, to now become operational as law. So when a
All right,
law
sir.
passes
All right,
through
all right.
all these
Hello.
requirements, yes.
I'm sorry to interrupt you again.
Okay.
I would want someone else to also contribute to. I wish we had a lot of time to listen to
All right.
your
Thank you.
discussion. I was actually enjoying it. Any
Hello,
other person
Council.
would like to contribute to the conversation? And please,
Hello,
what's your name again? The person who just spoke.
My name
Hello,
is Ramson Atindogo.
Ramson. All right. Yes, please. Yes,
Hello,
sir. The
Council.
second. Yes. Please, your name and would you like to contribute to the conversation?
Mine is, I would like you to allow him to add the fourth source of law, because he said there are four, and he spoke of three. So if you could allow him to add the fourth one, and then he goes.
Okay, sir. Ramson, kindly add the fourth one, then we take it from there.
I'm grateful for the opportunity and grateful, Senior, for this request. And so when you talk about the legal source of law, then you have to distinguish a bit, because a law may be legal but not formal or fail the formality test. Example is the case of Mensima, an ally that required producers of alcoholic beverages to necessarily belong to an association. The court declared that ally as inconsistent according to Article 2(1) of the Constitution, because the freedom of association is a guaranteed human right for the Ghanaian citizen. So that is a good authority for the legal source of law. Then the formal source of law talks about the content of the law, whether or not the law will pass the formality test, whether or not that law that has been promulgated is consistent with the provisions of higher authorities or higher laws. For instance, the 92 Constitution. A law may be passed legally, but does that law conform to the dictates of the 1992 Constitution, in which case the supremacy test under the Constitution, if it fails, then it has to be struck out. A citizen has the right to go to court to request that it be struck out to the extent of the inconsistency. So under the formal sources of law, that is where we introduce the sources of law under the Ghanaian Constitution in Article 11. Then we analyze from where the previous speaker took from up to the latter with the various authorities. So in summary, this is how I would have approached the question. Thank you.
Okay, thank you. Thank you so much, Ramson. Thank you so much. Any other person, or we end it there? Well, let's look at the second question instead. I like the views I'm getting. Let's read the second question too as well. I'll reserve my comments for my discussion today. The second question reads: the American business, but however, take note of whatever they have. Ramson and Priscilla have discussed. We'll come back to it. The American Business Association, ABA, has organized. Please, could we go to the next question? A minute, let me sort the next question out.
Please give me a minute. I'm trying to scroll, but it's also not working here. So I'm sharing it on the page so that we can all follow there too.
I believe there are some other people who are not on the page as well.
Yeah.
Okay, yeah, we have it now. So the second question reads: the American Business Association, ABA, has organized an expository visit to Ghana. Your cousin, who lives in the United States, has told the president of the ABA that you are a recent law graduate in Ghana. the president has contracted you to prepare a presentation to the ABA delegation on the fundamental principles that govern the formation of contracts for the sale of goods, in Ghana. Write the presentation. Please, who would like to also attempt with this question? I mean, I just want to hear your views on it. How would you go about it? Anyone? Bridget, I see Bridget Edem Agbozo. Madam Bridget, would you like to? Would like to hear from you. Hello, anyone? Any comments on the question? Any comments on it?
Hello.
Yes, hi.
All right. So this I see as a contract question, a contract law question.
Please,
But
what's your name, Joyce?
yes, please.
Okay, Madam Joyce, please, let's hear you.
So this is a contract law question. And so I would
Okay.
look at it from first of all, describing what a contract is and laying
Okay.
out the five okay, should I say five? Okay, so all the elements that come together to form a contract. So I'll look at offer and acceptance. I would also touch on that's after I've done my introduction a bit, and then I'll just the body and then a conclusion. So I would touch on offer and acceptance. I would also look at intention to create legal relations. I'll look at capacity to enter into the contract. Then I'll look at consideration. So these are the areas I would cover in terms of answering this question. Thank you.
Fantastic. Fantastic. Any other opinion? I need more views. I need to hear you. Any other? Any other? You have something to add? You have something to subtract? Any other?
Hello.
Yes, sir.
Yeah, I'm Anaba. In addition to
Anaba.
the last, yes, in addition
Oh,
to the
Anaba.
last paper, what
Mm-hmm.
I will approach you as formation of contract. I'll try
Mm-hmm.
to discuss what a contract is. Then I will zero on to the elements of contract. That's what she has already mentioned. Then I will try to differentiate or try to look at some of the reforms in common law that the reforms that our Ghanaian position has made, where maybe we can talk of consideration, the reforms on consideration, privity of contracts, some of the reforms, then maybe on frustrations of contracts under discharge. So these are some of the apart from what she has said, these are where I also target so that they'll know that even though we have adopted the common law position, most of them, but some of the changes we have made, I will include them in the discussion. Thank you.
Okay. Thank you, Anaba. Thank you so much. Yes. Thank you so much. I want to believe this would represent the general view of the entire group. And I think I get a fair idea of how you guys would mostly approach your questions when it comes to entrance exams. Like I stated earlier on, I said our meeting today is not going to be in the form of a lecture. I want it to be in the form of a discussion. I would have to repeat that. But then my fear, I don't doubt your knowledge on the law as at this point in time, because I believe everyone would have read a bit of contract law, a bit of Ghana legal system, a bit of land law, a bit of constitutional law, a bit of everything, thoughts and the like. And you should by now should have covered your bases. What I'm going to talk about now, please pay attention to it, because you'll not find them in any textbooks. You will not find them in any textbooks. A lot of times when we are preparing for entrance exams, we tend not to pay attention to certain little things. As little as it may seem or it may look, it's very, very important. Now, my discussion is on the strategies and how to answer Ghana School of Law entrance exam questions. That's why I started off by trying to pick your ideas from how to go about this question. By the way, the two questions we looked at is a past question from the year 2019. The year they filled a lot of candidates. I think 128 students passed out of 2,700 students or so. So that's the past question that we just looked at. So you can imagine the sort of responses that candidates we wrote. Now, first of all, what I'm about to share is based on my experience about the exams. And I must state this disclaimer alert. It is not an expert opinion or a rule of thumb. It's just based on my experience and conversations I've had with my friends at the bar and friends that have sat for the exams for a good number of times and finally made it. And these are little things I picked from a bit of something I picked from everyone. That said, I also like to premise my advice or my discussion on the fact that whilst we are aiming to score 100%, to do exceptionally well in the entrance exams, this exams is not to test your brilliance. Let's get that first of all. The entrance exams is not to test your brilliance on the law. Please, yes, it's not to test your brilliance on the law. I usually say that it's an elimination or a highly competitive exam. It's to select candidates to the Ghana School of Law, but not to test your brilliance on the law, whether you know you're offering acceptance, whether there's a valid contract or not, the number of cases you cite, it would get you in. It's more to do than that, than you knowing the law. So you would only pass if you do the right thing, apart from knowing the law. You would only pass if you do the right thing, apart from knowing the law. Now, assuming that this year they said they are taking 600 candidates out of 3,000. Just 600 candidates out of 3,000. You would have to make sure that you have to be part of that 600. And to be part of that 600, you only have to do what IEC wants you to do in the exams room, in addition to knowing the law. So your sole job there is to do what IEC wants you to do in the exams room, in addition to knowing the law. That said, you have to read instructions very carefully. You have to read instructions very, very carefully. You have to read instructions I can't overemphasize on this point. When we come back to the questions, you would understand why I'm saying that. You have to read instructions very carefully. Every little detail, pay attention to every little detail every little detail. You may receive 2 answer booklets in different colors. When you may receive 2 answer booklets, one may be pink, you may 2 answer booklets. Here now it's into 2 parts, part 1 and part public and private law. But I'll suggest that you wait for the question paper to read the instructions before you write your index number, title of paper, and those other things. Because Getting this part correct is as important as answering all the questions correctly. You have to read instructions carefully. You have to. You don't have a choice. Like you have to. Don't forget it. You just have it in mind that you are going to read your instructions carefully. Now, there's no hard and fast rule about which parts to begin first, but whatever it is, time. Don't spend more than 45 minutes on a question. Don't spend more than 45 minutes on a question. If you see that you are spending more than 45 minutes on a question, leave it and go to the next question. If you spend 1 hour on a question, just know that you are out. Like I said, it is not to test your brilliance. Entrance exams is not to test. So you have people that are exceptionally brilliant, bright students. They sit for the entrance exams and they don't get in. And you also find out that someone wasn't as brilliant as this person, but the person writes and the person gets in. That's the entrance exams for you. It's an elimination or highly competitive exam. Like I said, you pass if you do the right thing, apart from knowing the law. So you can't spend a lot of time on a question. Use 40 minutes maximum on a question.
Yes.
So that you. Hello, is someone saying something?
Mute yourself.
Oh. I wonder, what is this?
That is
People
Ghana for
behave
you.
like that. Why?
Yeah, Ghana for you.
Please go ahead. We are listening.
Thank you so much. So time, please. I'll beg you, time. Before I even forget, usually before you start, they give you 15 minutes to read the questions. Please don't miss this. Sometimes come and sit down when it's time for the paper, they are calling you to have your seat. We still stick around to let me read for the last, cram for the last. When they say start work, I can come in. No, you can't. If you do that, if you don't get that 15 minutes to read through the question before start work, you miss the point. You miss your opportunity. Because in the exams, you don't think in the exams room when it's entrance exams. You can't think in it. You just look at the question and start writing. The time to think is the 15 minutes that's usually given to you. So please, 45 minutes, it's 45 minutes. Don't spend more than 45 minutes on a question. And it's very important I also state that even 1 mark in an entrance exam is very important. So you should not even be heard saying I answered 3 questions because I spent 1 hour on question 1, almost 1 hour on question 2, then another hour on question 3. I didn't do question 4. You shouldn't be heard anywhere saying you answered 3 questions. Because when the instruction says answer all questions, answer all. If the instruction says answer 4 questions, answer 4 questions. Even if you are not able to answer 4 questions, please attempt 4 questions. If you are not even able to answer the 4, please attempt 4 questions. Because sometimes when you're marking and you see someone would answer 1, 2, 3, and probably hasn't attempted a 4th question, then you'd want to probably maybe, some marks, they are usually marks for attempts. Be as little as 1 mark, 2 marks, 3 marks. You miss out on it. No, that 3 or 2 could have crossed you from the fail list to a pass list. So please attempt or answer 4. Now, in answering the questions, go with your stronger foot. Please, in answering just go with your stronger foot first. I know it's quite normal for you to realize that you can answer one question very well ahead of another. Just begin with the one you have mastery on. And this suggestion only applies if and only if, please, there's a caveat here. This question suggests it's if and only if you are not instructed to answer the questions in a chronological order or in a specific manner. It's not beyond IEC to instruct you to answer question 1, 2, 3, and 4, even though they have given you 6 questions to pick from. It's not beyond IEC. The normal practice is that answer 2 from part A, answer 2 from part B. It is not beyond IEC for you to go, and then the instructions will be like, answer question 1, 2, 3, and 4. Or answer question 1 and 2 from part A, and answer question 3 and 4 from part B. It is not beyond IEC. Like I'll say, your instructions. Like all of you are aware, pay attention. We are general practitioners. We don't have specialists or like criminal lawyers or constitutional.
Some of these things are deliberate.
Themselves as such.
What's the meaning of all
you
this?
guys who are testifying to the fact that every Ghanaian lawyer can do
Kindly mute the
Why
person.
don't you just take him
It's
off?
coming from the host. It's coming from the
It is
host.
the host.
The
He has
host.
forgotten. Let's be patient and guided. I beg.
Lawyer just because you do. Hello. With.
Hello. Yes,
Yeah,
please,
hello.
let's move on.
Yes. All right. Anyway, so it's not beyond IEC, like I said, to instruct you to answer your questions in a chronological way or in a particular way. So please pay attention. If they say answer question 1, 2, 3, and 4, do it. And it's not just entering, that's their nature, what they do. Because I recall we start for an exam, that's the law school family law exam. Then usually family law, the standard general practice is that you have your compulsory question, which will be a divorce petition. So once you enter, we all know that you enter and write a divorce petition. You draft your divorce petition. We get to these exams, then they give us the facts, and in it, the question is advice and draft. A lot of us didn't see the advice because we are used to draft a divorce petition. We didn't see the advice. So a lot of us lost good marks on that part. Unfortunately, some of us were not able to pass the family law paper because of that particular lack of diligence on our part. Because you want to be a lawyer, you have to be very diligent in some of these things. And paying attention to detail is one of those things. So please, just take your time and read it properly. Now, in reading and analyzing the questions, I want you to have this in mind. You may choose to go with your first level analysis. I've spoken to a former lecturer, and he once told me that sometimes those who set and mark the exams, the entrance exams, may not come from academia. Most of them may be judges and even practitioners, and will not indulge you in deep legal analysis. Unlike the faculty exams you write that you are required to do deep legal analysis. So you may choose to go with your first level analysis option. And that is for entrance exams. I'll say the questions are never beyond you. They are never beyond you. Now let's go to the questions we looked at question 1. So that I'll use it to explain something. Question 1, please. Yes, question 1.
Okay, counsel is on mute.
Yes, question 1. I'm back. Now, we all read question 1, the facts narration in question 1. And I wasn't surprised by the sort of responses I was getting from Priscilla, very good explanation. In fact, Priscilla specifically says she will discuss, it's a discussion on sources of law in Ghana. And she said she should go on to discuss the various sources of law after giving a very good introduction and all that. Ramsey also came to take us to a jurisprudence class. Spoke about theories, discussion, historical sources, explanatory memorandum from case law, legal sources of law, and he did a very good discussion. That's a very solid discussion. Then he is not forgetting the fourth one, formal source of law. That's very solid. But if you read this question critically, let's read the question once again. Let's read. The question says, you have been awarded a Bachelor of Laws LLB degree from a university in Ghana. The gap period before you enter law school, you have taken up an internship at the Ghana's Law Reform Commission. The government of Ghana, with assistance from the World Bank's Legal Sector Reform Program, has initiated reforms in Ghana's legal sector, with the Commission as the lead government agency. A delegation from the World Bank is to arrive in Ghana for initial discussions on the reforms and had requested that the executive secretary of the commission provides them with a concise brief on the sources of law. The executive secretary has asked you for a draft of the brief. Write the brief. Who can tell me the question? Who can tell me this? So usually the point is that, let me just go ahead and reading this question, have in mind that there is always a question. Yes.
So this Nana Kwame, I'm thinking of starting from a memorandum.
Okay, Nana Kwame. Kindly hold your just hold on. You would have time for questions and would all deliberate on it. I want you to see something. Have in mind that there is always a question in every question. I'm repeating it. In every question, there is a question. When it comes to entrance exam, there is always a question in every question. Never forget this. Now, the question has given you facts. The facts ends at the executive secretary has asked you for a draft of the brief. That is where the facts ended, right? The question here is write the brief. The question here is write the brief. Now, if you tell me that you want to start by telling me theories, giving me theories, discussion, and all that, and you discuss historical sources, legal sources, formal sources, talking about explanatory notes and the like, yes, it is good academic work, solid, perfect. But the question is, have you answered the question? Because if you are going to do a discussion on theories, historical and all those things, and a discussion on the sources of law, the history, giving historical antecedents, you'll be ending up writing about 4 pages just the introductory part, 1 page, write historical sources, 1 page, write legal sources, 1 page, write formal sources, 1 page. And if I remember Ramsey correctly saying that when he's done with this, he will now come and start from where Priscilla started from, telling us that Article 11 is, then he proceeds from there. At the end of the day, he will write about 6 pages, if not more, for this question. But what did the question say? The question says, write the brief. In fact, they said, provide them with a concise brief on the sources of law. Provide them with a concise brief on the sources of law. So you can't be seen to be writing more than 3 pages for this question and beating about the bush, going around it and not rather answering the question. So you finish and you've come out and said that, oh, Charlie, the question was on sources of law. Charlie, I killed it, I killed the paper. But you didn't answer the question. The question says, write the brief. The question says, write the brief. But you've done a very good academic paper. which would even pass to be published in one of the legal portals as a very good, solid article. But I'm sorry, it won't pass. It won't get you a spot in this exam that I say is not to test your brilliance on the law. It's not to test, it's just to select candidates. So you only pass if you do what they want you to do. Please, any question on this before I go to the second question?
Yeah, so the brief you are talking about. So how do you go about it?
Yes. So with a question like this, they say write a brief. Just go straight to the point. Go straight to the point. You just say that, oh, the sources of law in Ghana can be found in Article 11 of the Constitution of Ghana 1992. They are Constitution, Act of Parliament, so and so, so and so, so and so, so and so. Then you take one, Constitution, explain, support it with an authority, close it, conclude it. Go to the next one, Act of Parliament, explain, support it with an authority, close it. Take the third one, explain, support it with an authority, conclude it. In that manner, go straight to the point. You are writing a concise brief. No one really cares about the theories, the historical antecedents of how the sources of law came about and all that. Personally, that's how I go. And seniors that sat for this paper and made it, I asked them. And in fact, this is the guide they gave me. That is how most of them approached it. I also asked those who didn't make it in that year. And some of them gave me the answers and the responses that ordinarily we all would have provided in the exam hall, like trying to, how do you call it, write a lot and show our mastery of the law and how we know also the historical antecedents and all those things. Maybe someone that day who is not so much of a bright student, a sharp student, only has studied Article 11 and decided that, hey, Article 11 is the only thing I have, so I'm going straight. That person would have made it. And another bright student would not have seen it, would try to express himself and will not make it. And come out and you don't understand why this person in class, I used to teach this guy, but this guy made it. But the guy you are saying you used to teach him, he didn't have anything to write. He just went straight to the point to write, make his point. Please, are we getting it?
Yes, counsel, thank you.
So that is it for that question. Let's go to the second question. And you see something again. Let's go to the second question. Just pay attention. Please, a minute.
No, it's not showing this. Council, please, I'm scrolling, but it's not showing here.
Also, before we get to the second question, I just want to ask one or two.
Yes, sir.
Please
proceed.
Yeah, okay.
Please proceed.
Senior, I just wanted to find out. So, with a brief, do you have to do intro before you come to the body and short intro?
Now, with the brief, yes. Mm-hmm. So, with the brief, every essay should have an introduction, body, and conclusion. Have that in mind. Have that structure, please. Now, your introduction here is The sources of law in Ghana can be found in Article 11 of the 1992 Constitution. They include the chosen to Constitution, Act of Parliament, blah, 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 blah. Then just get your introduction should be more than 5 lines, I must say, when they are asking you to write a brief.
Okay.
Your body would include you taking the Constitution as one source of law, explaining why the Constitution is a source of law, support it with relevant authorities, conclude on it. Then you take Act of Parliament, explain why Act of Parliament is a source of law in Ghana, support with relevant authorities, conclude on it, take the next one, do same to each and every point. Then you come and conclude. Please say, are we okay?
Yeah, thank you, sir.
You said you had another question. You said you had 2 questions. What's the second one?
See, since you've answered it in that, I'm okay with it, Senior.
Oh, thank you. Thank you, sir. Please, any other question before we proceed to question 2?
Sorry, my name is Moses. I want
Moses.
to, from your analysis, the sense I get is that in looking at the context in which you as a candidate you are demanding to write is to, while you are writing on the source of law, you should look at sources of law that can be amenable to reforms, right? And not necessarily the theoretical or prudential aspect of it, right?
That is so.
And then the second question from your explanation to you can, okay, sorry, then let's proceed since you have not tackled the second question.
Council, I have a question.
Yes, please proceed.
Yes, I want to know whether there is a structure for a brief as opposed to when you are asked to write just an ordinary essay. For instance, also, let's add a memo.
Hello.
There are structures for those kind of essays so that we'll be aware of.
Yes,
I'm actually Council. I mean, the structure of a brief and then that of a memo. For instance, if you are being asked to put this in a memo form or a brief, legal brief, is it the same thing as the normal essay structure?
Okay, so I would address that later.
Okay.
Now that I would address that later. Hello, I'll address that later, but now that you have brought it, I think I should mention it under it. But let's look at the second question and we look at that as well. The second question says that the American Bar Association has organized an expository visit to Ghana. Your cousin, who lives in the United States, has told the president of the ABA that you are a recent law graduate in Ghana. The president has contracted you to prepare a presentation to the ABA delegation on the fundamental principles that govern the formation of contracts for the sale of goods in Ghana. Write the presentation. That's the question. Now, we had responses from Madam Joyce. She said she'll tell us what a contract is and lay the elements of a contract, and she will proceed and explain each and every one. And Abba also came in to say he'll discuss what a contract is, elements of a contract, and in fact go further to say the difference or the reforms in the common law position and the Ghanaian position when it comes to with respect to consideration. That specifically he will end up discussing when someone asks you to leave an offer open for a specified period of time or part payment of debt, specific legal obligations, and all those things. The Ghanaian position and the common law position, he will do all those discussions. That's a good spot. But like the first question, have you seen the question here? Who can tell me the question here again? From the first discussions we've just had.
Write the presentation.
Exactly. The question now is write the presentation. So they are giving you facts. So let's read. The American Bar Association has organized an expository visit to Ghana. Your cousin, who lives in the United States, has told the president of the ABA that you are a recent law graduate in Ghana. The president has contracted you to prepare a presentation to the ABA delegation on the principles that govern the formation of contracts for the sale of goods in Ghana. They have not asked you any question. They haven't asked any question. They have only presented you facts and what they are expecting you, they want you to do. Have they not asked you any question? The question now proceeds. Write the brief. Sorry, write the presentation.
Yes, presentation.
Now, writing the presentation, the responses that I have gotten, which I said is a fair representation of the whole group today, is that you will tell me what a contract is. You tell me the key elements of a contract. That is from Madam Joyce, representing all of us today. I never support Madam Joyce in representing all, and to say that we will discuss what a contract is, elements of a contract, and differentiate and talk about the reforms from the common law and the Ghanaian position. That's our position today. But sorry to say, if we present our answer like this, 99% chances is that we will not make it into the, we will not get a spot when it comes to some of these things. Reason being that the question has given you, the question is asking you to write a presentation, and they are giving you a topic for you to make the presentation on. And if you see the topic, is in quotes, the fundamental principles that govern the formation of contracts for the sale of goods. So if you're asked to write a presentation, what would you do? Your every presentation must have what? A title, a heading, right? Hello?
Yes, you are on. Please go.
Yes, we are here. We are listening to you.
All right. Every presentation must have a title. Every presentation, so you start with a title, as been provided in the question already for us. Presented to, the question also tells us who it should be presented to. It told us, right? The American Business Association. Prepare a presentation to the American Business Association delegation. So presented to the American Business Association. Imagine a candidate presents his answer like this, and another one comes to just do a normal discussion on the sources, the fundamental principles that govern the formation of contracts for the sale of goods in Ghana. Who do you think would pass? Who should more marks be given? You should answer that yourselves. Who should more marks be given? You have come to give us a whole discussion on the topic. Another has also come to answer the question. When you write a presentation, you are now answering the question. But to do the discussion, you are only giving us facts, but without answering the question. That is the point I'm trying to make here. So back to the question a colleague of us just asked about memo and brief and those things. If I were you today, I'll be thinking around. If I'm hello.
I don't get it. I don't get it. Huh.
Please, is it not possible for the host to mute everyone?
We keep trying to mute them and they keep turning on their microphone settings.
It's actually the same person. It's the same person.
It should be removed.
Jesse, please, our apologies. Please, you can continue. Thank you.
I've forgotten what I was talking about. What was I saying?
You're talking about memo, comparing the memo.
Yes. Colleague who asks questions to know the format of writing a memo and a presentation and all that.
Yes, sir. Yes, sir. Thanks for the reminder. So I'm saying that if I were you, I would be thinking around. If I'm presented a question today, that, okay, there is some constitutional review going on presently. And I enter the exams hall and I get a question that you are an intern, you have recently graduated from the University of Ghana School of Law, and you are doing some bit small internship with or you have been invited to be a researcher to the Constitutional Review Committee. The chairman of the committee has asked you to write a memo detailing 5 reforms that you think should be amended from Ghana's 1992 Constitution. Just some kind of question like that. Write a memo to. You should be having that thought. How are you going to go about it? I'm not saying a question like that would come. It's something I'm just thinking loud. You could meet something like that. And they may even try to link it with the removal of the CJ, Article 146. They may try to link it with separation of powers. They may try to link the removal of the CJ with separation of powers. We'll never know. But my point is, writing the memo should take in the form of a memo. Memo has a format. Subject. Is it date? Let me see if I can get a sample here.
Sure.
Yes, I have a sample here. A friend wrote his memo to the Constitutional Review Committee regarding some concerns regarding the constitutional recognition of specific voluntary associations and the need to reform them. He offered his opinion. I'll share it with you. So that you guys can look at it. I don't take credit to this work. It is from my brother and my friend at the bar. I'll share it so that we can look at the work he did. A very good work he did. But that is just because he was submitting to the Constitutional Review Committee. You can also write all these in the entrance exams. That is my fear. Guys, time. So I'm forwarding it to the admin so that she puts it there, then we all see it. The work my friend did. Admin, I forwarded something to you. But anyway, let's proceed. So that is how it's supposed to take. The form in which it's supposed to take, right? You have to, the person, Constitutional Review or the chairman of the Constitutional Review Committee, then you put your index number, date, September 6th, 2025. Subject, then you put your subject there. And most likely they'll provide you with the subject. Yes, thank you so much. Just a bit. So this is work done by my friend Frederick Agaya Dongo. He submitted this to the Constitutional Review Committee and he shared a copy with me I asked for a copy, then he shared it to me to read. And good stuff. This is his opinion that he feels that constitutional recognition of some specific voluntary associations and they need to reform them. like the Bar Association. You have in the Constitution, they say that probably maybe Constitution of the General Legal Council, you need a representation from the Ghana Bar Association. Freedom of association. So imagine if we have another bar association, which is not the GBA. It means that particular association will not have representation on the table when it comes to the General Legal Council. Is that what? Because the Constitution has embedded in it that you need a representation from this specific association. And that's the angle he comes from. I hope it's clear.
Yeah, it is.
Yes, it is, Council. Yes, thank you.
But this is the format that this is the format of a memo. Not forget about the rest of the things that he has put there. But then for entrance exams purposes, you have your memorandum there to from dates. Let's go to the first. Scroll up a bit, up a bit, up a bit, up a bit, up a bit. Professor
about the numbers?
H. Kwesi
Can you
Prempeh,
also look at the
Chairman
numbers?
Person, Constitutional Review Committee from Frederick Agaya Dongo, date August 6, 2025, subject concerns regarding the constitutional recognition of specific voluntary associations and the need for reform. Then introduction. So you should always have your introduction, then your body. So for entrance exam, just have your introduction and have a body and conclude, right? So to make things simple, just have that in mind that it should take the form of a memo. If they ask you to, the first question we looked at, that you needed to write a brief sources of law. If they're asking you to put it in a memo form, you do what? Let it take in the form of a memo. If the entrance exam question says discuss, please discuss. If they say list, please list. If they say list and explain, list and explain. That is the point I'm trying to make. Please, are we clear?
Yes, sir.
Yes, Council,
So
we
what
are clear.
happens is that
We're grateful.
So what happens is that a lot of us read the set of facts, and afterwards we go straight to answer without even caring to see how IEC expects us to answer it. All this ranting, this lot of English I'm saying, it all sums up. We should always read the facts and also be interested in how IEC expects us to answer the question. So people see what they are supposed to write on. Oh, we are supposed to write on sources of law. But how to write it, we don't see that. How to write the sources of law, we don't see that. And like I said, the key to passing these exams lies in how you write it. Not what you are supposed to write to, but how you write it. So there is always a question in a question. Never forget this thing. So they can give you long set of facts, but they have not asked any question yet. Oh, contract law, for instance, contract. Kofi and Ama, when Ama offered to sell his yellow Peugeot car to Kofi, and Kofi did this, and Ama did that, and blah, 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 blah. And Kofi traveled. Ama left the offer open for a period of seven days. Ama never heard from Kofi. And Kofi wrote a letter to Ama. They haven't said anything yet. They haven't asked you any question yet. They're just giving you facts. So what is the question in that particular question? Then you come and see, oh, the question says, address Kofi as to so and so, or address Ama as to so and so, or advise Kofi or advise Ama. So how you write it is very important. Now, if it's a problem question, this is also very important. So far, what we've discussed, there are basic questions. Now, if it's a problem question, by the way, I don't have his permission to share these documents. So, but it's academic for academic purposes. If it's a problem question, They will give you the set of facts. Sometimes they may give you the set of facts and put some questions under them. They have done it before. For instance, they'll give you a set of facts and ask, 1, what are the remedies available to Kofi or Ama? 2, does the High Court have jurisdiction to entertain Kofi's action? 3, are there any defenses open? Are there any defenses open to Ama? If you go through your past questions, you'll see things like in previous years, they've asked questions like that. When it's something like that, please do not raise issues. They have already raised the issues for you. Do not go and write your own issues out of the issues they have, the scope they have limited you to. Answer their issues and conclude. If you, however, see something like advise Kofi and Ama, then you can raise your own issues. But if they are very specific, what are the remedies available to Kofi? You need to answer those questions. In fact, some people, so it's a matter of style. Someone will say that, oh, he used those questions to raise his issues. Another person will go like, oh, I'll go straight to, those are the issues, so I'll go straight to address it. As to remedies, then I'll advise Kofi if they ask me to advise Kofi. But do not go outside the scope they have given you. Please, do not go outside the scope they have given you. And also note that IC can ask you to advise a specific character in a question as to a particular issue. They can, for instance, they can say, okay, advise Kofi as to the equitable remedies available to him, or as to his equitable remedies. Then you have someone who would raise nice issues, do a very nice analysis, legal analysis, and would not answer the question. The question says, advise Kofi as to the equitable remedies available to him. So if you've done all that, yes, please.
Counsel, please, from what you are saying, if the issues have been cited in the passage, can you rewrite the issue?
Oh yeah, some people do that. That's why I said it's a matter of style. But you should also have in mind that, in mind of time constraints. Examiners who give these questions do not want you to go outside the scope they have given you. Because they know that if they allow students can raise some issues that will not even be found in their marking scheme, and you are forced to mark, and they'll be right. You can't fault the students. Because it's a legal matter. Anyone can raise it. That's the issue the person sees, and the person has raised it. So if they limit you to a specific scope, please stick to it. It's also possible they will say advise, like I'm saying, advise this person as to a specific remedy. They are being specific about it. So even though you have raised your issues and all that, if your issues will not lead to you advising Kofi as to that specific remedy, you have the answer for yourself. Please, am I clear?
Yes, Counsel, you are clear.
Yes, my lord.
Yes, Counsel.
Please take note, and I'll rehash on it. Advise Kofi means advise Kofi. Don't go and advise the parties. If the person wanted you to advise all the parties, the person would have stated it there that the examiner would have said advise the parties. If they say advise Kofi and Ama, don't go and advise Kofi and leave Ama, or advise Ama and leave Kofi. If they say advise the parties, then you can advise everyone. That one, you take each and every one and advise. My advice to Kofi is so and so. My advice to Ama is, my advice to Kofi is he can bring up an action to recover damages against Ama for breach of contract. My advice to Ama is that Ama can raise a defense on so and so. or Amma has this defense in law against Kofi. So you advise each and every party. Please, are we clear?
Yes, we are, counsel.
Yes, we are.
Please, any question?
Counsel, I have a question. So,
Please,
for
sir.
25 marks, is it possible
Yes.
that all that the IEC will be asking is, let's say, what remedies are available to one party when the question in tort probably has 4 or 5 people in the fact pattern? I'm trying to understand that, because what we've been made to know is that when it gets to, let's say, your relevant laws, you will be guided to write all the issues that you have found in the problem question, and then your analysis will deal with all the parties that are in the question. I need some clarification, please.
All right, sir. So 25 marks for just advising the person. The 25 marks is not, first of all, the 25 marks is not just for advising the person. The 25 marks, what makes up the 25 marks is, first of all, your area of law, your issues you raise, your assembling of the law, your analysis, and your advice. Now, what happens mostly is that you are over 3,000 candidates sitting for the exam. If an examiner should spend 5 minutes on your script, how many minutes would he spend reading everyone's script? So most likely, they'll look at your area of law, look at your issues, look at the laws you have assembled, go and look at the advice. Please, are you getting it?
Yes,
now,
counsel.
You may do a very good discussion, good analysis. They'll look at it, but they'll not spend a lot of time because there are other scripts to be looked at. They'll not spend 5 minutes to look at one particular script like that. It's not possible. 5 times 3,000. Even if the person is marking 300 scripts, and the person is spending 5 minutes on each script, or 10 minutes on each script, that's a lot of time. And it's like I said, it's not to test your brilliance. It's an exam. It's a selection process. So do whatever they want you to do and go. Now, the other bit about the assembling of the laws. What my friends and I did was that we raised the issues. We raised the area of law. We state our area of law. If it's probably maybe consideration, or probably maybe how do you call it, damages. The question also it's on damages. You'd say there's a way usually. A minute, please. Yes, you just state your area of law. Area of law, remedies for breach of contract, specifically damages. That's how personally I state my issues. I state my area of law. If it's on equitable remedy, remedies for breach of contract, specifically equitable remedy. If it's on offer and acceptance, I'll say what? Elements for the formation of a contract, specifically offer and acceptance. Now, I'll raise my issues that I find very relevant from the facts case scenario given. Now, when I raise my issues, every principle I know in offer and acceptance that I may need in my analysis or my application, I'll state it there. Every principle, I'll state and explain every principle. Every authority, I'll state it there. I won't say, I know 10 or I know 5, but I'll state 2. I won't take that risk. I'll state all the 5. And if in my application, I decide to use only 2 to do my application and make reference to the other 3, that is fair enough. Please, are we clear? It is a competition. If you know, please, if you know and you have time, please state them and explain. If you know and you don't have time, state some and explain some. If you don't know, there's no problem at all. You should know the principle of law. That one, you don't have an excuse. You should know the principle of law. They don't really care about you citing cases, the name of this case, the name. All we are concerned is the principle of law. Principle of, what does the principle of law say? So it's possible you may have read the case and you would have forgotten the case title and all that. State the principles there. There's a joke we usually tell someone to present a script. There's in a decided case, in a decided case, in a decided case, in a decided case, like that. But the 25 marks is not just for you advising one party. It's comprising of other aspects of your answer that you present. Please, okay. So it's possible that area of law can take 2-3 marks. If they are generous, 5 marks. Issue, the number of issues you raise, probably maybe each issue will take 1, 1, 1, 1, 1, 1. Your authorities assembled laws will take probably some marks. Your analysis will take some marks. Then your final conclusion will take some marks. But the danger here lies is you have done all that and you have not advised who they are asking you to advise. But the marking scheme says that 10 marks for anyone who advised AMA. The person marking will not even go and look at may not look at your analysis you have done. The person will just go and look at did your advice tailor-made for AMA? Oh no, the person was advising Kofi. The person will give you 1 or 2. You've lost 9 marks or 8 marks. Or probably maybe if the person advises this, give this marks to this. If the person advises, I hope we all have seen a marking scheme before, how a marking scheme is done. It's not done in detail like how we present our responses. It only addresses certain things. 5 marks to a candidate who does this. Issues should be raised around this. A student who does this, 10 marks. So most likely, it is the person who marks. It will be his or her discretion to give or award certain marks. You may not get the full mark, but you get some mark. That's even if you have done what they expect you to do. So the 25 marks, yes, it covers a lot of things, not just the advice bit. But you'll be safe if you do what they want you to do.
Thank you so much, Counsel. This is helpful. Thank you.
Hello, Counsel.
Counsel, please,
yes,
let me come in
hello.
with
Yes, please. My
question.
name is Solomon.
Yes, Solomon.
Hello. Yes, Counsel.
Yes.
I want to find out some of us have had other people guiding us in federals to, writing this exam, and their advice to dealing with the ARAG method of responding to problem question is that we don't state area of law as was done in the past. Let's say, the issue has to do with battery, then say area of law, battery, then come to list or itemize the issues, then come to rules, come to application, then in discussion and in that order to conclude. Now they are saying that we should, put it in a sentence form. This question invites me to discuss battery, or let me say assault, as the thought or the area of law, and to deal with it, I shall address the following issues. Then you put them in that order. What's your position on this?
I would also agree with them. Reason being that it's the same IRAC, but a different form.
Okay.
There's nothing wrong with it. It's the same IRAC with a different form.
Okay.
This question borders on remedies for remedies for the breach of a contract, specifically damages. To address this issue, to address this fact scenario, the following issues, I'll use the following issue to address this fact scenario. Then this, like that. Then I come and take my relevance. In addressing this, I heavily find support in the following authorities. Then I list them. My authorities I explain. I list, I explain. I list, I explain. I list, I explain. I list, I explain. Come and do my analysis. Analysis underlined neatly. Then I do my analysis. From the facts, don't forget that phrase. From the facts, so in applying the authority in NTHC versus entry, or in applying the principle stated in Hong Kong Fair case, then you go, then you conclude, then you advise. It's a matter of style, right? But my advice is that do what you not spend a lot, what you are comfortable doing, first of all, and what you will not spend a lot of time doing. Your sole goal is just try and answer the question. Whichever style is okay, it's correct.
Sir,
Some people
sir.
also
But then you
yes.
deal issue by issue, Council. Is that correct? You deal the issue by
Yes,
issue.
issue by issue, issue by issue. Yes, issue by issue. Issue by
Sir.
some people usually please let me land. Some people usually state all their issues, state their relevant authorities, and take issue one, apply the relevant authorities, conclude on issue one, take issue two, apply, conclude, take issue three, apply, conclude. Then they'll come and do a general advice. If the question says advise the party, then they'll now advise the parties involved. The reason why they do that is that in case they are unable to finish, they get marks for all the issues they have raised. But if you state issue, relevant authority for the issue, apply, conclude, then you now state your second issue, relevant authority, apply, conclude, third issue, and they say stop work. You would have raised 2 issues. Meanwhile, you knew about 5 or 4 issues. You lose marks for issues. Do you get it? Secondly, when marking, marks are awarded for issues listed. So you would have lost. So for instance, they say 5 marks for raising issues. So the issue aspect, the part that you raise issues, you lose mark. The examiner may lose sight of the fact that you have not raised an issue. So he adds the mark that he would give you to your issues, to your analysis and stuff. I don't know if I'm making sense. Instead of having a separate mark for the issue, in marking, it's possible that an oversight, then he will not give you mark for the issue, but he give you mark collectively for the entire resolution of the issue. When you could have gotten an extra mark for raising the issues before you take one of each and every issue to address. Please, are we clear?
Yeah.
Council.
Yes, sir. Council.
Yes, sir.
Hello, Council.
Yes, sir.
Yes, sir. Just a quick one on what we are discussing. I just want to find out there are other views that after you stated your area of law, the issues as you are explaining, then you've listed your rules or the applicable law. Under the analysis, must you repeat your authorities that you've cited under the rules, or you can just state from the facts, then you conclude? From the facts, you just state your position. Must you repeat the cases or the authorities that you've listed under the rules, when you are at the applicable law?
Yes, sir. You need to, in your application, you need to now tell the examiner that from the fact, Kofi agreed to buy 50 cartons of tomatoes from Amma. Amma supplied the tomatoes. However, Kofi refused to accept delivery of the tomatoes. Amma kept the tomatoes in her warehouse and it got spoiled, and Amma is now trying to claim some. So you address it when you address from the like that, then you repeat, not repeat, you cite an authority to support your analysis to make the point that yes, Amma should have done what mitigated her losses, for instance. Probably maybe take the tomatoes, find another buyer in the market, probably get the market value price, sell it, and come and sue for the damages after mitigating your losses. Then you cite your authorities under that. Please, you get it? You don't just state the issues. You don't just state the issues, state the authorities, and come and just say from the fact, Amma can sue Kofi because so and so, and leave it. You have not done any analysis. Analysis is now using the issues, using the authorities you have raised and applying it to the facts and drawing a conclusion that as a result of Amma's inactions to mitigate her losses, she cannot recover the entire 50,000 contract sum. Do you get it? Then you rely on authorities that will support your case. Okay.
Counsel, please,
Counsel,
my question is, would it be necessary if, for example, the area of law is contract law, and then you say that area of law is contract law with specific emphasis on maybe consideration? Like, do we need to state the substantive court, so to speak?
If not to, that would have been the case because previously entrance exams, we used not to know where the questions should be coming from. You the brain set of facts, and a set of facts could contain thoughts, contract, constitutional law. Do you get it? At the time, because you just go, they'll bring two questions, and one question could be either be mixed up, cocktail. You find some issue on thoughts, you find issues on contract, you find issues on criminal law. So at the time, you see people say, "Oh, this area of law is contract law." Specifically, the area is this. But now you have part A, part B. If you say it's contract law, specifically consideration, why don't you just tell us the area of the specific topic, say consideration, specifically part payment of debt? That's more okay than saying contract law, specifically this. That's you have to be specific about these things, that your area of law is consider elements of a contract, more specifically consideration. That is fine. Someone can say area of law is how do you call it? Consideration, specifically consideration under contract of law. Let me be very because consideration could be used in any other thing. Consideration under contract of law, specifically past payment of debts. That's also more specific than to say contract law. Contract law is so broad that
no, Counsel, sorry for interrupting, but my point is you state that and then you add the other ones to maybe elements of, a valid contract or something like
that. Some people do that, but that's why I earlier stated it's a matter of style, and everyone would want to put it there. But please, let's not leave our chances or our hope to get into the law school for someone to decide. Let's decide it today. That let's do what would get us in. If there's a doubt, be very specific.
I have a question. I have a question. Is it right for us to, subtitle the work? For instance, issues. You write issues, title it, then you now list the issues. Go to rules. You write rules, underline, then you flow with your rules in that order.
Oh yeah, it's right. In fact, it makes your work legible. And let me add this: don't box things together. In leading paragraphs, please in leading paragraphs, leave one line as a paragraph. Personally, what I do is that I leave two lines so that you are able to see that, okay, this is it. Don't box things and do the indented paragraphing, because we don't all have legible handwritings. But in as much as we don't have legible handwritings, please try to make it as clearer as it can be. You may be writing good stuff, but your handwriting may be the problem. Maybe the person marking was tired at the time and wants to finish. You've written this thing like this, and you don't paragraph it like that. So if you title it issue, then you state your issue, then you come and, if some people can do it, you can do legal relevant authorities, underline it. Then the person lists and explains all his relevant authorities. Then the person come and do analysis. Then the person starts analyzing the work from the facts. So in resolving issue one, I rely solely on Article 2.1 of the 1992 Constitution, which provides that. In fact, paraphrase it in your own words. You don't need to, if you are able to cram it verbatim, that is fine. But paraphrase it in your own words. And please, don't write when they are proper nouns. Don't use improper. Don't use how do you call it? How do I even put it? Instead of the word beginning with a capital letter, you use a smaller alphabet to describe those proper nouns. Okay, those are the little things that you would circle, underline, circle, underline, circle, underline. So please, the general structure of your work should be neat. We can't all have good handwriting, but at least make it presentable. You can leave one line as a paragraph or two lines as a paragraph. And before I forget, in your answer booklet, on each page, write your index number on top of each page. There's a reason for it. They ask you to write your index number on each page of your answer booklet. Each page, it's possible, there are a lot of scripts. So make your work, let it look very neat, legible. Leave a paragraph, right? If you have time, you can underline your authority self you stated. If you have time, get a ruler. If it's Article 11, then you underline Article 11. If it's NPP, New Patriotic Party, but versus the Inspector General of Police, then you underline it neatly like that, so that the person marking sees your authorities without even reading them. And don't box things. These are the little other things that, and thanks for the question, sir.
Sir, please, I have a question.
But wait, I'd have another class at 3, so I'd have to leave you guys in the next 30 minutes.
Okay, cancel.
Yes, sir. Please, the lady was asking a question.
Yes.
My lady, can you kindly ask your question before we take the next?
Just a minute. Can we do this in a more orderly manner? If you have a question, just raise your hand so that right after the person, I'll call you, then you take over. So please, let's take the lady and the next person. Kindly raise your hand. Thank you.
Okay, so my question is, if you're moving from one paragraph to the other or from one issue to the other, is it good to use words like furthermore, firstly, to add, to begin with, and stuff like that? Or do you just go to the first issue says this, and this is how I analyze it?
So if you are very comfortable using linking expressions, you can use them, but be very careful when using them, because someone will say first, and meanwhile, the point the person is making, we never see a second. Do you get it? If you are saying first, there should be a second, there should be a third, there should be a final point made. Someone say first, and we'll not see a second point. But use linking expressions. In fact, it actually make your work flow, especially when it's an essay form of a question, an essay type of a question you are asked to discuss. And when you are using the linking expressions, know the one you are using, the one you are comfortable, but don't, and please.
Good morning,
Grammar. And please, grammar. I know it's a competition, but don't try to use a language that, I don't know, that it will be difficult for any other person to appreciate. In simple language, it's not the legal jargons and the legal, no. It's not about that. That's why I said your first level analysis of the issues, your first level analysis of it. In fact, the questions have never been above anyone. They have never, it's how you put it. So my lady, you can use linking expressions to at least present your work. It helps in the flow from one paragraph to another paragraph. It links it joins everything together. It weaves your essay together. So you can. But then leave a paragraph when you are going to the next point. Leave one line. A line when you are going to the next point. One whole line as a paragraph when you're going to the next point. Present your answer, your work like that. Please, the next question.
Okay, the next question. Joyce, please, you can unmute.
Yes, please. Thank you very much. I wanted to find out for the second question we answered, beyond the title for the presentation, what else do you do? Because we seem not to have exhausted that one and then we moved on. Thank you.
You are most welcome, ma'am. The second question, beyond the title, it says we should write a presentation. So after you've a presentation to so and so and so, you should have, every presentation has an introduction. Your presentation should come with a body. Your presentation should come with what? A conclusion. So like I said, have in mind of these 3 steps. Whatever form of essay you are writing, just know that it should have an introduction, body, and conclusion. Specifically with the second one, they are saying fundamental principles that govern the formation of contracts for sale of goods in Ghana. Now you have your introduction. Your introduction would probably include you listing the principles that govern the formation of contracts, offer acceptance, intention to create legal relations, consideration, and the like. Just like that. Now you take them one after the other and write on. Please, am I clear? Just know that
yes, please. Thank you very much.
Your body will include each and every point, each and every principle, element that you raise in your, so that if the examiner or the person marking reads your introduction, the person can even summarize what the person should know what you're about. I should be able to look at your script in your introduction and say, this candidate knows her stuff. I shouldn't waste 5 minutes to know whether you pass or not.
Councillor, on a memo, do we conclude on a memo?
Yes, you should have a conclusion in it. Entrance exam purposes. It's not, that's why I said the one I've sent you, you have an introduction. The one I sent you have an introduction. You should have a conclusion. Conclusion basically to summarize everything you have said. And that's the easiest way to conclude. Don't do in conclusion, Amakansu or something. Or in conclusion, the separation of powers in Ghana. No. Like, just do a summary of what you have said. And you are done as it becomes your conclusion. So every essay you write, every question you answer, if it's in the form of an essay form and not, should have introduction, body, and conclusion.
Okay, cancel.
But not to say that you come and list, sorry, sir, but not to come and say that you underline introduction, come and underline conclusion. That's not what I'm saying. Please get me right.
Okay, cancel.
Yes, sir.
Yes, we hear inciting or making reference to cases. You can do that by using red ink. What's your take on that?
My take is that, please, you don't have time. And our advice against it, whether you have time or not, don't do it. You are using red ink to do that. The examiner, what pen would the examiner use to mark? The examiner obviously will use red ink. So if it goes for moderation, what would they say? Did the examiner write that for you? Please, if you have time, you do even have time to even be changing pens? You see, the entrance exams, like I said earlier, you don't enter the exam room there to think about what to write. You don't think in the exams room. You go there having gone through the review of the question. They give you 15 minutes to go through the questions. That's the period you should use for your thinking and assembling your authorities down, assembling your issues, assembling your authority. That 15 minutes is for you to choose your questions. Choose wisely. It's possible you can do everything. Doesn't mean that you should take questions that would take a lot of your time. Okay, so you even get time to even be changing pens. You write, use green pen. Some will use red. Then, see, you can't use any other pen aside blue to stay on the safer side. Use your blue pens. If you want your authorities to be legible, just get a ruler. You can even deepen your authorities if you want and underline it neatly. And let me say this. Let me say this. I'm saying this. Some people get half time to answer their whole question in caps. Caps, oh, caps. You have time to be writing in block. Please, you waste your time. Just write normal like how you write normal. If you are supposed to use your caps, you use the caps. If you are not supposed to, you don't use it. But you can't write the entire essay in caps. Reading, it makes reading difficult for the examiners, I must say. But when I speak to seniors, and these are some of the issues they tell me about. You have people that will write in caps. Don't waste their time to read it. After all, you've taken yourself out of the competition. So please stick to blue. If you use red, the examiner, what pen color would the examiner use to mark the paper?
All right, I'm grateful, sir.
Hello, sir.
Please,
Hello,
let's
sir.
take
Yes.
Helen, please. People had their hands up, so
Okay.
kindly
Very well.
put your hand
Very well.
up. Let's take PD first. PD's iPhone. Your hand has been up, so you can unmute. If
Yeah, so
he's not ready.
yeah,
Okay.
my question is, I've been told that when you are answering an essay question in your introduction, you first have to tell the examiner how you understand the question or what the question is required of you. And then you give a structure of how you're going to answer the question. So in the first part, this is what you're going to do. And in the second paragraph also, you do the next thing. And then you state some authorities before you now go into the main introduction. So it's like the first part is just an outline of how the work will be structured. Can we use that approach?
My lady, I'll repeat it again. People have a way they answer their questions. As to having an outline, your introduction can also make up your outline in a way. This question bothers on sources of law in Ghana. Then they try to give an outline how they'll address the question. I've seen it before. People do that in their introduction. But to have an outline before the main introduction, I haven't. I don't think it will be appropriate to do that. But if you want to have an outline, try to find a way to put it in your introduction. After you've introduced, some people try to introduce the topic and try to do this. But I tell you, there will not be time for you to do all that. I tell you, please, if you have time, yeah, it's fine. It's also cool. People do that. So that when the examiner takes your script, the examiner reads your introduction. You now tell the examiner how you are going to approach it. Approach it. People do it, but personally, it's not something I would have time for. I would answer the question. and go as such. But people, it's nothing new. I've seen it before. People do it.
Okay.
And let me say this, please. Let me say this. Entrance exams, I know a lot of people would tell you their experiences. Oh, this is how I answered it. There's no like I said, it's not a rule of how to go about the questions or something. What's important is you always having in mind that there is a question in the question. Try to answer the question. Write a presentation. Put your answer in the presentation form. If they say write a memo, write the memo. If they say write the brief, write the brief. Don't give them 4 lines. If they say write the brief, then you're giving me outline, and you end up wasting your time, and you give me about 5-6 pages. You see, when you do that, most of the examiners would look at the script and go like, you haven't even answered the question after giving me an historical incident on how the sources of law came about and all that. So please, always situate it with the question that's present. Don't have in mind that you are going to do introduction, body, and conclusion. However, your introduction, the form that it will take, that's left onto you, but it shouldn't exceed 6 lines or so, or 5, 6 lines, 7. No. Go straight to the point and answer the question. Yes, please.
All right,
Next.
thank you. We have just 20 minutes to go. So for those who have raised their hands, that's all. Nobody should raise again. So now we'll take Conrad.
Hello, senior.
Yes, sir.
Yes. I know the IEC exercises some discretion as to how they set their questions, but from your experience, should we expect any other type of questions apart from an essay type question and IRAC?
Aside essay and IRAC, have you seen any other form of question before?
I haven't.
I also haven't, sir. It will only be essay and IRAC based on with entrance exams and all that. I don't think there will not be any question I don't even know of any form of question aside essay on IRAC.
And just to be clear, if we are asked to write a brief, a memo, or asked to write, yes, a brief or a memo, is still an essay question.
Yes, sir.
Okay, thank you.
Your job is just to have in mind that what is the question about? How do they want me to present my answer? That's your job. That should answer a lot of, that should help you be a guide. What is it about? What is this question about? How do they want me to present it? How do they want me to write the answer? What and how? What and how? What is it about? How do they want me to write it? Have this thing in mind. Just have it in mind. So there's always a question in every question. Yes, next, please.
Okay, so we'll take Joyce. Joyce.
Madam Joyce.
If Joyce is not ready, let's go to Helen.
Okay, thank you. I'm grateful. So, my counsel, my questions are under the rules and application, can you give them subheadings? For instance, rules for issue 1, and then you write on that rules for issue 2, you do that, and then you go to rules for issue 3. And when you come to the discussion of the laws, you also have application for issue 1 as a heading, application for issue 2, and in that order. My second question is, we have been asked
Madam, please wait. Please wait. Let's take the one after the other. Now, with the first question you just asked, please don't use that structure.
Okay.
Don't use that structure that you would have to raise rules for issue 1, rules for issue 2. Then you come and do analysis for issue 1. No. Like I said, first of all, state your area of law, raise your issues, right? You have relevant authorities. Your relevant authorities may be from issue 1 and issue 2, right?
Okay.
And explain everything that you want to use to resolve the question. Now, when you are addressing issue 1, you now come issue 1. Some people even do issue 1, underline it nicely. Then you'll come in resolving issue 1. I'll heavily rely in the following authorities, or the authorities are relying on so and so and so and so. Do you get it? Then they now come and do the analysis like that. Then they conclude on that issue and go to issue 2. In resolving issue 2, I heavily rely on Article 42 of the 1992 Constitution. This is the so and so, so and so. Then they put it there. In resolving issue, and they analyze it and they conclude on it. And if you've been listening to me, I always say analyze and conclude. Close every point you make. The third one, in resolving issue 3, I will heavily rely on the authority in NT80 versus NP, or Carlin versus Carbonic slope ball. So. Then you do it. Then you come in, and from the facts, you can be. This is a case on all fours. Then, like, you do your analysis, apply the principle of law to it. What was said in NT80 versus NP, that an offer must be definite, firm, and final. It should leave no room for further negotiation. But from the facts, the offer made to Mrs. A wasn't so definite, and it left the offer. It left everything in doubt, and it left room for further negotiations. So applying that principle as was stated in NT versus NP, so then you conclude on it. Therefore, the purported offer is not a valid offer made to Mrs. E. Then you leave it like that. You have not advised, you have concluded. Then you now come and do the next one. When you are done, then you come. If the question says advise Mrs. E or advise the parties, then you say advice to parties. Then you take I. My advice to Kofi is that so. I. My advice to Mrs. A is that. Then I'm done. Please, do you understand? But don't use the structure that you. If not, you may not finish, and it will make your work very clumsy.
Okay. All right.
Yes, the second question.
The second question is, we have been asked to and always underline the cases. Do we also underline the sections and the articles?
Yes. So please,
articles.
Please, when we say authorities in law, it includes sections, it includes cases.
Very well.
It includes constitutional provisions.
Very well. Okay.
It includes acts of parliament. So if you want to rely on Contracts Acts of Ghana, Act 25, Section 8.1 and 8.2, which deals with leaving as payment of debt and leaving an offer open for a specified period of time and blah. Underline them, like Section 8.1 of the Contract Act of Ghana. Then you underline it.
Well.
All those are authorities. So when they say authority, it's not just a case. So if they say in fact, thank you for bringing it. If they say provide authorities, and you know of a constitutional provision, provide it. That is an authority. Don't say you don't know any authority because you didn't have a case or you can't remember a principle of law. That is an authority.
Very well. And Council, the first 15 minutes that are given for us to read over the questions, are we actually allowed to write? Because I know there are exam regulations. If you are not allowed to write and you start writing, the examiners may...
You are not, the 15 minutes, you are not allowed to write as a start work. Do you get it? But you are allowed to, in fact, when you are reading your question, you have a pencil or something. And in fact, if it's an essay form of questions, each line you are reading and you see an issue, just underline it or put there 1 or issue 1 on top of it. If you go to the next line, then you see that, oh, this can be an issue, then you put there, 2. If you consider, you say, oh, this is 3. So that when they say start work, you know where to find the issues, not to come and reread it again. Okay? Now, when you are reading, when you are done spotting the issues, at the back of your answer booklet, you can put there question 1. Maybe I want to answer question 1 and 2. I can put question 1. Then I'll put my issues down. I'll state the issue 1.
That's within the 15 minutes.
Yes. Whether or not this. Whether or not that. Then I'll put my authorities for issue 1. Maybe MPP versus IGP. I'll put it the MPP versus IGP. I'll put the Article 21 of the Constitution, ART.21. Then I'll put ART.130. Then I'll put JH Mensa versus AG. Then I know that issue one, I have more authorities for issue one. Do you get it? So that when they say start work, I'm not going to now be thinking. I'll just stand at the back of my answer booklet. I'll look at, what is issue one? Issue one, then I'll write it. What's my authority? MPP versus AG, then right. MPP versus AG, what's the provision? What did they say? What did they say in it? In MPP versus AG, the court held that so then I leave it. Go to the next one. Article 2.1 provides that so then I put like that. And mind you, if you have a constitutional provision, please mention it first before you come to the case law. That is the hierarchy of laws we have. In your answer, they look out for that. You can't write MPP versus IGP before you come and write Article 2.1. You would have turned it right opposite. So you stay to Article 2.1, stay to Article 130. Some even go for to even state Article the supremacy of the Constitution 1.2 before they break it down in that order. Now come and support it with a case. Please,
very well, Council. I'm grateful. Thank you.
Yes. You're most welcome.
Take the last question from Johnson Simone.
Yes, Council. Please,
Yes,
with
sir.
respect to if the question asks us to give a brief, would it be right to first give, like, before you start answering the question, you give the area of law? Would that be right?
Come again, please.
Let's say, like, with respect to the first question, they asking us to give brief. Would it be right to first give the area of law before you start answering the first one?
The first question is yes, area of the first question is, so you have to be mindful. Like I said, this is a 2019 paper. Now, before now, the area of law, you should have stated you were mandated to state the general area of law. For instance, if it's a constitutional law question, or you have to determine whether this is a constitutional law question first or a contract law question. Now, with this specific question, which sources of law? They have already told you the area of law. They need you to write the brief. So just go ahead and answer the question. But however, if it's in a form of probably maybe a different form of response, like for instance, they give you a fact scenario like what should I even use? The removal of the Chief Justice. And they link it with the concept of separation of powers in Ghana. And they want you to advise a party. Then in your introduction, you'd have to let it capture that this question borders on, do you get it? The separation of powers. Do you understand?
Yes, I do. Thank you. Appreciate it.
Something like that.
Hello, Council.
Please, I'm coming. If they expect you to do something like that, you can capture that in your introduction. Then you proceed to do your analysis. Yes, someone was saying something.
Yes, this is Nana Kwame.
Yes, sir.
So yes, I'm using myself as an example. I wrote last year, and some of the things that you said, yes. Last year I realized that they gave us two booklets, different booklets. So immediately I read the question, I started answering. So when I saw I had done with a full question, then I realized that I didn't answer that question in the right book. Now I need to transfer that question into the right book. So when I saw that, I realized that I have failed the last year's exams. So as you are saying, the things that you are saying, you are right. If you don't take time and go through and read instructions, in fact, you may have all what you have, but it will be difficult for you to pass. And for what I have deduced from what you said, it is also advisable to always read the question before the fact. You read the set of facts. Because if you are not careful, you confuse yourself before you come and read the question. Thank you, sir.
You're welcome, sir. Thank you so much for your contribution. Before I forget, and this is my concluding Yes.
Yes, sir. Thank you. Just a quick one. How the authorities that you have to state in hierarchy, are you to do that under the rules or when you are in the analysis?
When you are analyzing your stuff,
Oh, okay. So under the authority,
yeah,
you
when you
can
are
just
analyzing your
okay.
Oh, because they don't really focus on it. But the focus is on when you are analyzing your stuff. You can only write what comes to your head first, right? But when you are analyzing, you have to be very careful about writing it. Article comes first. If there's a constitutional provision, fine. If there's no constitutional provision and there's an act of parliament that makes provision for it, state it, section this. But you can't state a case before it's an act of parliament.
Okay, thank you.
In your analysis.
Another quick one. Some also advise in other books that if you're using the IRAC, you can, after stating the area of law, you can write something like introduction before you proceed with the issues. And I want to know, is that also a good start by introducing?
No, IRAC is IRAC, and it's a matter of style, like I said. Some people may do IRAC without necessarily doing issue 1, issue 2, issue 3. They may say, oh, this question borders on the formation of contracts, specifically offer and acceptance. The following issues can be deduced from the fact scenario presented. They'll put their column or semicolon, then they'll put I. Whether or not so and so to I, whether or not so and so I, whether or not so and so, then they'll come. In resolving these issues, I heavily find support in the relevant authorities stated below. They'll start I. NTAC versus entry provide the court held that an offer must be definite, final, and leave no room for further negotiations. Gibson versus Manchester City Council provides that. Pharmaceutical Society of Great Britain versus Booth Chemists also held that. So. Then they state them there like that. Now, when they are done, they do not come in issue 1. In addressing issue 1, I heavily find support in the case of in Gibson versus Manchester City Council and ATAC versus entry. From the facts in Gibson versus Manchester City Council, as stated by this, the court held that so and so and so and so and so. From the fact, you can tell that the offer made by Mrs. Benny left room for further negotiations, as announced in so and so, that such a statement does not amount to a valid offer. In conclusion, Mrs. Benson cannot be said to have made, or the purported offer as claimed by Mrs. Benson cannot be said to be an offer. Then you conclude it. In resolving issue 2, please, do you get it? Like, that's how you're supposed to go about it. Okay.
Please, respectfully, can you go over that point again, please?
The point as to how to go about it.
Yes, please. Respectfully.
What I just did.
I'm sorry about that.
So what I said was that, so in answering the questions, you don't need to just go straight. Some people may not necessarily list issue 1 to issue 2. No, some people may start by saying, this question borders on formation of contracts, specifically offer and acceptance. That may be their first line. And the following issues can be used from the fact scenario presented. Whether or not the statement or the offer, the purported offer made by the company to Mrs. Gibson amounted to a valid offer. Whether or not Mrs. Benny acceptance or letter rights relating to the company amounts to an agreement formed between her and the company. Now, when you're done with these things, then they'll come again in their relevant authorities. They'll come in resolving the above issues. The following authorities, we rely heavily on the following authorities to resolve the above issues. Now they start NTAC versus entry. In NT versus entry, the court held that an offer must be firm, valid, firm, definite, and final, and should leave no room for further negotiations. They leave a line and go to the next point, the next authority. In Gibson versus Manchester City Council, it was held that so they leave a line and go to the next one. In Pharmaceutical and Society of Great Britain versus Boots Chemists, it was held that in Agnes versus Gramophone, it was held that damages were not made for punitive purposes, but for restorative purposes, to put the innocent party in the position where the innocent party would have been if the contract was not breached. Then they ended there. They do not come. In addressing issue 1, I find support in the principle stated in NTAC versus Entry and Gibson versus Manchester City Council, where the court held that an offer must be so and so, must be definite, final, and so and so. From the facts, the purported offer made by the company was not firm, was not definite, and left room for further negotiations. In that they said that if Mrs. Gibson and Mrs. Benny wants to make a formal offer to the company, she should write and apply, stating with a price. Mrs. Gibson's letter to the company lacked these three things, didn't have such and so, didn't state a price, didn't state this. To conclude, and you're applying the principle in the cases stated above, it can only be concluded that Mrs. Gibson didn't make a firm offer to the company, or the offer blah blah blah. Then you come and you conclude. Then you go to the next one, the next issue, and you do same for the next question. Says advise the parties. Then you say your advice. Then you put advice to the company. The company can so advice to Mrs. Benny. So Mrs. Benny can so. Then you are done. That's what I said. Hello.
Thank you very much, Jesse.
Yes. My concluding remark.
Yes, please.
I leave here today having full confidence that you all will make it. You pass your exam and you ultimately become lawyers. And secondly, I'd like to say that just be confident in yourself. Don't let fear put you down, and don't panic. Don't panic. Sometimes you get to the examination center. I remember my time, we're about to write 5 minutes to the paper, then someone came. Charlie, what is the principle in Cramo Wala versus something else? I say, hey, which case is that? So you see all sorts of things happen in the exam center. So please don't panic. Don't panic. Someone will be mentioning cases. You think, hey, you there, you are working, you are not really studying, you are behind you. I totally understand. I've been there before, and we are in this together. You will do well, and God will be with you. Now, have this in mind, especially when it has to do with constitutional law cases. I forgot to bring it up. Constitutional law questions. A constitutional law question, there is possible they will give you a fact scenario like the removal of the Chief Justice issue. When they give you facts like that, please read it carefully. They may give you facts like that, but they may not ask you to address Article 146. They may not ask you to address the removal of the Chief Justice. Let's say they have given you facts like that, and the question proceeds that, and in the fact situation, and Mr. Bond, a British national, is not happy, or probably maybe the Law Society of London and Law Society of England and Wales are aggrieved by the removal of the Chief Justice, and they have come to you to file a petition or file a writ at the Supreme Court or for a remedy. They are not happy, and they've come to you as the lawyer, advise the Law Society of England and Wales. That alone has changed the entire scope of the question, from you discussing the validity or the constitutionality or the unconstitutionality of the removal of the Chief Justice. Whether to capacity, the issue on capacity. Please pay attention. Now, they have given you, because they know that everyone is so hyped up about it. Students will be paying attention to it. Students want to express themselves. Oh, Article 146 is unconstitutional for the president to do that. It's not unconstitutional. But they're not asking you for that. They're saying that the Law Society of England and Wales, comprised of British nationals who do not even have standing in Ghana or are not citizens of Ghana, that's the point I'm trying to make, are not Ghanaians, want you to invoke Article 2.1. That's the question. So you ask yourself, where's the area of law now? The area of law is not on the removal of the area of law is not on capacity. Whether who can bring an action under Article 2.1? That's the question they need you to answer. Can anyone bring an action under invoke the exclusive original jurisdiction of the Supreme Court under Article 2.1? What does the case law say? Please, do you get it? Hello?
Yes.
Very clear.
Yes.
We are here.
Please, do you get it?
Yes.
We are here.
So, like I said, there's always a question in a question. That long fact they are giving you, TJ, they've removed the Article 416. The president set up a committee to remove the chief justice. The committee came out with its report, and they said that the chief justice should be removed. The president issued a statement and said that remove the chief justice. And the Law Society of England and Wales, or Mrs. Benny, who is a British national, is aggrieved and thinks that the president's move is unconstitutional and has brought a writ to the Supreme Court of Ghana, and you being the lawyer to represent him, to seek for an interpretation or declaration to that effect. Now you have people who sit down, spend their time to tell us Article 146, and that the president acted unconstitutional, the president didn't act unconstitutional, and whatever, what have you not, so and so, and the committee, fair hearing, injustice, the chief justice wasn't given a fair hearing. Have you answered the question? The question is on capacity. Whether a foreigner can invoke the exclusive original jurisdiction of the Supreme Court, and that's good too. So someone who is diligent and pays attention to detail will see this and go like, and go. First of all, Article 1.2, supremacy of the Constitution. Then go Article 2.1. Oh, Charlie. Then he writes there, Charlie, who can bring an action? And you bring the most popular cases. You state all of them. State all the popular constitutional law cases would have addressed Article 2.1. Come and state Article 130. Then the person is going like that. Then Nipano, he doesn't even know that he's doing the right thing. Meanwhile, you being the brilliant student would go and express yourself and come and you'll not pass. And the person who did what he saw would pass and you won't understand. Please pay attention. Pay attention. I beg of you. And these are my concluding remarks. I wish you the best of luck. And I wish we had more time because I need to go and assist my boss. We have a class at 3. I need to go and assist him. So we'll talk. But I'm always available if you want any clarification before your exam. I'm always available. You can reach out to Nana. She'll link you to me and we can have a further conversation. I'm so grateful and thanks for your time.
Thank you very much.
Thank you very much.
Thank you so much.
Thank you, senior.
Thank you
God
very
rest.
much.
Thank you
God
for your
bless
time.
you.
Thank you for your time.
God bless you.
Grateful. Thank you very much.
Thank you very much.
So we end the class for this morning, but we'll reconvene again at 6
Thank you.
p.m.
We are grateful.
The constitutional law class. So 6
Please,
p.m.
can we reconvene at 7?
Thank you very much.
I feel that some of us are going for the food now.
The constitutional law lecturer has limited time.
Hey.
He's only available. So please.
Please, the recordings of the contact law and all that. Put the recordings on the page for us, please.
For the recordings, right? Please, for the recordings, we'll share the recordings with you. The Zoom, we are working on it. However, go to our YouTube pages. We save them there every day. So you'll find it on our YouTube page, Ghana School of Law SRC. You'll find it there. Check the live videos. As we are here, we are streaming live. So you'd find it there from the beginning till the end. So please go to YouTube for now. Thank you.
Hello, Nana. Can I talk to you about something? Nana,
you can send me a message. You can text me.
Okay.
Now, some of us are trying to join the group, but